All right, thanks for joining me, everyone. Charles Moscowitz, Monday through Friday, 12 noon Eastern Standard Time, here live at YouTube and podcasted on subscribing platforms. Welcome to the program. My guest this segment is Michael DeGrandis. He is with the NCLA, nonprofit civil rights group founded by prominent legal scholar Philip Hamburger. I had the honor to interview Mr. Hamburger years ago. Very good guy. New Civil Liberties Alliance. They're bringing a lawsuit here in my own state of the Commonwealth of Massachusetts with regard to COVID-19. Michael, thanks for joining me this afternoon.
Thanks for having me.
All right, so let's talk a little bit about the lawsuit here to try to challenge these various decrees emanating out of the office of Governor Charlie Baker with regard to COVID.
Yeah, as your viewers are probably well aware, Governor Baker declared a civil defense state of emergency on March 10th, 2020, and that state of emergency continues. And I think it's important to note that it's a civil defense state of emergency premised on the governor's authority in the Civil Defense Act. The Civil Defense Act is what it sounds like. It is an act to protect Massachusetts from invasion, armed insurrection, rioting, and there's a carve out for things like fires, floods, earthquakes. And so governors have used this statute before to protect Massachusetts in times of hurricanes, nor'easters, tornadoes, that sort of thing, but never for a pandemic. And part of the problem here is that not only did Governor Baker choose the wrong statute, in choosing the wrong statute under which to act to protect Massachusetts' health and safety from COVID-19, he ignored or suspended the Public Health Act. The Public Health Act has been around for over 100 years, and it expressly provides powers to state and local authorities, not to the governor, but to other state and local authorities, to protect Massachusetts from epidemics and pandemics. And that's what he's done, and that's the problem that we identified at NCLA. That's the interests of the plaintiffs in this case, and that's why we thought it important to challenge Governor Baker on this, because his legislating, which is what he's doing under the Civil Defense Act, his legislating are executive decrees, and executive decrees violate separation of powers. Only the legislature can make law.
Right, and the law, the civil, his utilization of the Civil Defense Act to implement these decrees. What would have been the proper remedy, and what was the law that existed before that which he overlooked, and how would that have been implemented?
Yeah, so the public health, and maybe I should even back up a little bit. I think some people are concerned about lawsuits like ours, and there have been a number of like ours across the country that have been successful. It's not that what we want is COVID-19 chaos. That's not the end result of this. The end result of this is effectuating the policies in the Public Health Act, like as you're asking. The Public Health Act allows border towns to prevent travel from outside areas. And Governor Baker, of course, has instead said, I don't care what that statute says. That statute allows local boards of health, so local health professionals, to make a determination. There is in coordination with the state board of health, that there is an infected area which they don't want travelers coming through Massachusetts, and they can get a warrant, the local board of health can get a warrant to quarantine someone or to force them to leave Massachusetts. But Governor Baker instead decided that he would suspend that aspect of the Public Health Act, and that he would have his own quarantine rules for out-of-state travel. And so that's just one example of how the Public Health Act already addresses this issue, but Governor Baker decided to override that and effectuate his own policy preferences. The Public Health Act also provides for regulations by the Department of Public Health. And the Department of Public Health, over 16 years ago, issued regulations that named novel coronavirus by name. I mean, it's explicitly novel coronavirus. Mm-hmm. So it's not that the Public Health Act had no idea that this could ever happen. It's that Governor Baker has taken over, where if new laws needed to be passed, the legislature's been in session. They could have done that the entire time. They could have changed the Public Health Act. They haven't done that.
Now, the Public Health Act, it seems to me, is more set up to address or to allow the local cities and towns to address their particular problem. Massachusetts, like 3 other states, is a commonwealth. And I learned a little bit about what that means when I had to go to a school for drivers because I had too many tickets. And the teacher explained that as a Commonwealth, the cities and towns in this state have more power than they do in most other states, and they can do things like pass, and it can be for the good or for the bad. I mean, they could pass very strange driving laws, and when you enter into a city, you don't know that all of a sudden, the mileage has changed, and you could get pulled over. But the point is that under that tradition, if you will, this seems to me that this health act would have addressed COVID-19 depending upon the community, and that there are many communities, at least half of the state, have had no cases at all, and other communities maybe a few, and there's really only a few big hotspots, including Boston, or my neighborhood. We're here in Boston, and other towns like Chelsea and Lynn. And this is similar to the response at the very beginning of the pandemic, I recall, in New York State, when there was one community, I think it was New Rochelle, that had an outbreak of COVID-19. And what happened is that one city declared a state of emergency, and that it was in place until the situation was remedied, in that people were properly quarantined or hospitalized in some cases, and then things went back to the status quo ante. And it seems to me that that is a more democratic approach to this problem. You have local city councils that are in session and mayors who can make decisions about their own community based upon the unique circumstances of that community, rather than have the state step in with this big overarching law that covers the entire state. Now you're pointing out, and I think rightfully, but we'll see what the Supreme Judicial Court says, that such an overarching decree, especially when it was not at the consent of the legislature, is unconstitutional on a state level. Is that right?
That's right. And because what we're talking about here is exercising what's called the police power. And the police power is a power to regulate public health, public safety, and public morals. I mean, and just think about that. And that's, by the way, a quote from the Supreme Judicial Court decades ago. Think about that. Public morals. Do you want an executive to be regulating the public morals? You certainly do not. And so, policy, again, this is a separation of powers issue.
Right.
Policy must be established by the legislature. I think it's interesting to look at the Jacobson against Massachusetts case back around the turn of the 19th to 20th century, in which the United States Supreme Court said that a state could pass a law to forcibly vaccine residents. So there have to be some exceptions and so forth, but just for the sake of simplicity, put it that way. The factual underpinnings of that are very interesting. The legislature in Massachusetts passed a law that said, look, if a local board of health sees an outbreak of something like smallpox, then the local board of health can step in and get the local government to then mandate vaccines to prevent the spread of smallpox. And that's what happened in Cambridge in the Jacobson against Massachusetts case. Mm-hmm. And there was a clear line of authority delegated from the legislature to a local board of health. Again, these are the health professionals on the ground seeing the problem develop and try to avoid that. It's an entirely different circumstance than what we have here, where the governor has taken away the power of local boards of health. They act essentially as his health police. They have very little influence, very little authority. And I should also make it clear, it's not that under the Public Health Act, the local boards of health are totally untethered. I mean, they still do coordinate very closely with the Commissioner of Public Health to identify threats and to coordinate with local communities and other local boards of health to prevent spread.
And also, from putting aside the constitutional questions, which is based on the American system of subsidiarity and local government, and rightfully, on a health standpoint, it makes a lot more sense to have something addressed like that. And that's what President Trump has tried to do on a national level. I mean, he's allowed the states to regulate their own response to the virus, and some states have none. Other states like New York and California have a lot. And I think that has been the more democratic approach, the more constitutional approach, and the better approach from a health standpoint, rather than have a national lockdown. I know that there are people on the left who have a more authoritarian orientation calling at the time for a national martial law, basically, a complete national lockdown. And, to me, that does not seem certainly as a good idea from a constitutional standpoint, but it's also not a practical idea from a health standpoint, because it's not necessary. It's an overreach. and it's a use of a genuine problem, which is a pandemic, to do just that, to overreach. So, here in Massachusetts, we are having an overreach. Now, Governor Baker's draconian laws, that's happening in other states around the country, probably in, various unique permutations. I mean, it's not, they don't all have the same type of laws as we have, but it's being thrown out in other states. As you point out, just recently in Michigan, Wisconsin, Pennsylvania. We have judges who are standing up and saying, stop, not so fast. This is not constitutional. What's going on in the rest of the country?
Yeah, it is a little bit of a mixed bag, but I think that there is a clear trend where courts have identified, in Michigan in particular, I believe it was, they said that where the legislature hasn't provided anything more of a standard for a governor to declare a state of emergency than that which is reasonable or that which is necessary, there's a non-delegation problem. And so we talked about the police power, and to your point about how President Trump has handled this at the national level, the police power is exclusive to the states. That's a constitutional issue. It's exclusive to the states. And so there's only so much the national government can do. And so states have to take control over the situation and keep their own residents safe. And some states like Michigan do have emergency powers acts for the governor that are a little bit different than Massachusetts. Massachusetts, the Civil Defense Act is clear with respect to this being a civil defense emergency. What is or is not a civil defense emergency, I should say. A pandemic is not one, is our argument in the case. In Michigan, there was an element of delegation where it appeared that the legislature did allow the governor to declare a state of emergency in the event of a pandemic. But then the governor kept renewing the state of emergency. And the court finally said, hold on. There's no real standard here by which the legislature has delegated. So all they did was just give away their police power, so the power to make policy relevant to the health of communities, to the governor. First of all, that's suspect. Second of all, if there's no durational limitation of this, the legislature's got to be very, very specific about what the governor can and cannot do. And they didn't do that. And so the Emergency Powers Act, under which the Michigan governor was operating, was declared to be unconstitutional, an unconstitutional delegation of the legislature's exclusive authority to make law to set Michigan policy. There's one other case as well that I think is particularly interesting, and that is the Pennsylvania case. That was a federal court case. Michigan was the Michigan Supreme Court. In Pennsylvania, the issue there before the federal court was one of First Amendment, freedom of assembly, and 14th Amendment due process and equal protection. And there the court went out of its way to say, look, we think Governor Wolf really did do his best. And it goes into excruciating detail regarding everything Governor Wolf did in creating a record of what he thought would be best in aligning life-sustaining company or businesses, I should say, and non-life sustaining. In Massachusetts, it was essential versus non-essential. And the court said, it doesn't matter that you have good intentions. Good intentions isn't a constitutional standard. You don't have the authority. This is a separation of powers issue. You are violating due process. You don't have the authority to legislate like this and take away people's livelihood. They have a substantive due process right to earn a livelihood. The legislature can do what the legislature wants to do, obviously within the confines of the Constitution, but clearly a governor can't just step in and take away people's right to earn a living, right to associate with one another, and so forth. And I think there is an emerging trend.
It's also troubling that you have this sort of arbitrary power placed in the hands of a governor to decide what's in the best interest. And then they may not do things that are in the best interest. Like we could point to New York, where Andrew Cuomo overruled a federal statute and put COVID-19 active people into nursing homes, the most vulnerable segment of the population, which resulted in thousands of deaths. I mean, at least by association. We can't absolutely point to that, but certainly not a wise or moral decision on his part. And this happened in other states as well, probably Massachusetts to an extent. So, if we're going to give arbitrary powers to a governor over, as opposed to local diffused powers overseen by elected legislative bodies, then we ought to remember that, and we ought to be very careful. Now, if in fact these laws are rescinded as they were in Michigan, that doesn't mean that people can suddenly go out in a mob and take off their masks and go into restaurants and breathe on everyone. People are going to use good common sense because nobody wants to catch this terrible disease. What do you think, in absence of such decrees, is the best policy publicly for society to proceed in these times?
Well, and NCLA is a nonpartisan, nonprofit civil rights organization. We don't get into policy issues, and I made that clear to the Supreme Judicial Court when one of the justices asked me, "Don't you think Governor Baker's done a darn good job?" And that's neither here nor there.
Right.
The issue of constitutional order. And so I think that the right thing to do is simply let the legislatures legislate. Go ahead, now that the Michigan governor's orders are invalid, the legislature needs to hold hearings, needs to understand better the dynamics of the disease, understand better the communities in Michigan and how they're affected, and go ahead and pass laws accordingly to make sure that people will be kept safe. That's really the right process, because we see what happens when we don't follow that process, and we end up with these comorbid social, economic, spiritual, and certainly constitutional crises on top of what started as just a health crisis. And I don't say just a health crisis to minimize it, but it needn't become this substantial, like I said, social, political, intellectual, religious, economic crisis that it's become because we've left our constitutional moorings. You need the Constitution most during a crisis, not least. And these governors have just totally thrown constitutions aside, saying, "Hey, it's an emergency. You got to let me do what I want to do," and that's made the problem much worse.
Oh, on all levels, as you mentioned, and also it's a naked grab for power that is fiat, that doesn't exist in the Constitution, and that's something that experience shows governments don't like to relinquish once they have it. So it's a very, very dangerous precedent. It sets a very bad example, particularly for younger people who don't really understand the Constitution that well. They're not taught it in our public schools. You don't find the Constitution in public school. So they might get used to the idea of the government coming in and passing these mandates and penalizing people, arresting people if they don't follow these mandates without questioning the legality of the mandate in itself.
Right,
Now,
because one thing, I think just to tag on there, I think you've got a really important point there. It's that Governor Baker, for instance, isn't always going to be the governor of Massachusetts. You may like this governor, but what about the next governor? COVID-19 won't always be a crisis in Massachusetts. What about the next crisis? Is it going to be a real crisis? What authority does that next governor have? And just imagine that the next governor is the politician that you distrust the most in this world, and that person is your governor. What sort of precedent do you want to establish for this next governor? I think you want to restrict the governor's power.
Yeah, and I think you need to look at the Constitution. Article 1, Section 8 says that all legislative power, all powers to make law, resides with the legislature, the Congress, the House of Representatives, and the Senate. And Article 9 of the Bill of Rights and Article 10 say that all laws not specifically relegated to the federal authority reside with the states and with the people. So you have state legislators and the federal legislature, which is Congress, have being granted or recognized as the sole legal and lawful authority to make law. And if we stick with that system, we're going to be a lot better off. Now, people are crying about whether or not the federal court or whether or not the Supreme Court might overthrow the Roe versus Wade decision. Well, the answer to that, again, is legislative. If that happens the next day in Massachusetts, the state legislature will probably vote in a similar law to Roe versus Wade, probably worse, but putting that aside. In other words, they're going to guarantee legal abortion in the state and in other states. And if they don't, then it's up to the people of those states to elect representatives who they think should. So that's how the system should work. That's how it has worked. That is called democracy, to use a term that has been abused by people who actually support authoritarian approaches. And that's what we're talking about here.
That's right. Yeah, I completely agree. And I think as long as you appreciate that the whole point of a constitution is to protect the people from momentary passions and prejudices that become particularly inflamed during times of crisis, I think then you really understand that there's an importance to this process, that it isn't just rote ancestor worship type of thing.
Right.
There's real legal reason for this, and it's to protect our civil liberties.
And it's to protect giving power to individuals to make stuff up as they go, whether it be a governor or whether it be a Supreme Court judge. The people have the sovereign right under God, I would argue, to control their own lives and destinies, and then to elect representatives to represent those goals and destinies within the confines of the written law, the Constitution. So, Michael DeGrandis, I know that your lawsuit was heard at the Supreme Judicial Court right around the time that Chief Judge of the Supreme Judicial Court, Ganz, passed away. Now, I think that might have slowed things down in terms of your process. So tell us, where at this point is your case?
Well, yes, sadly, Chief Justice Ganz died. I think it was 2 days after oral argument. My understanding is that he had intended to, of course, participate. His death was a bit of a surprise. And so that probably did slow the process down. It has been a little bit over a month. Oral argument was September 11th. It's hard to say, and it's hard to predict how the highest court of the state operates. There is sometimes some horse trading that goes on behind the scenes, because our case was on a rocket ship to the Supreme Judicial Court. We didn't have any lower court opinions. And so what ordinarily happens in these circumstances is if the justices are deadlocked 3-3, then the lower court decision would stand.
Right.
But we don't have a lower court decision. And so I know, I'm very confident that the justices take our case very seriously. I think they want to have a resolution sooner rather than later. It doesn't help anyone, regardless of which side they go. It doesn't help anyone to let this drag out. So I'm quite sure that they're doing their best to push this forward in an expeditious manner. It just may be difficult because they've got 6 and they really need to come up with something. So I'm afraid that's the best I can give you.
I know, I understand. They need a tiebreaker, just like the Supreme Court needs a tiebreaker in case there's a question about the election. That's why it's important to get Judge Barrett confirmed, in my opinion. But you have no inside knowledge or anything about any timeline or any point at which something is going to happen.
No, justices rarely share that information. They've never shared it with me.
Right. No, I get it. All right, Michael, let my listeners and viewers know about your organization and where they could get more information about you and your group.
Great, thank you. Yes, the New Civil Liberties Alliance, you can find us online at nclalegal.org. As I said, we're a nonprofit, nonpartisan civil rights organization, and our primary focus is on administrative state abuse, but that extends sometimes to presidents and governors like Governor Baker, where they act as Uber administrators. Our primary tool is original litigation in state and federal courts, which is why we're in Massachusetts in this particular case. And so that, again, nclalegal.org, go there and donate to support our cause. That would be very helpful. We would appreciate it.
Very good. I'll put a link to it on the show. And Michael DeGrandis, I want to thank you for joining me this afternoon. Very interesting talk. Thank you.
Thank you for having me on. I enjoyed it.
All right.